This is All India Radio. In the program News Analysis, we now bring you a discussion on Supreme Court's decision on right to privacy. The participants are Dr. Subhash Kashyap, Constitution expert, and Satya Prakash, journalist.
In an important verdict, 9-judge Constitution Bench of the Supreme Court has declared right to privacy a fundamental right. There are experts who are saying that this is perhaps the most important verdict since 1973, when Supreme Court declared, or rather Supreme Court propounded the basic structure theory. Dr. Subhash Kashyap, tell us how this verdict is important, because we are in an era where right to privacy, many people are saying that it will cover so many aspects and the kind of implication it will have for various cases pending before the Supreme Court.
Every judgment of the Supreme Court is important, particularly when it comes from a 9-judge bench. But it is not for the first time that the Supreme Court has said that it is a fundamental right or it is not a fundamental right. In 2 cases earlier, the Supreme Court said it is not a fundamental right.
That was MP Sharma versus Satish Chandra, 1964, right. And then Karak Singh, 1962.
In 2 cases, it said it is not a fundamental right, which is the right position because it is not included in the chapter on fundamental rights in the Constitution.
Part 3
of the Constitution, which mentions the fundamental rights. Right to privacy is not there. The Constitution makers and the Constitutional Assembly discussed the question of including right to privacy and decided not to include it. So it is not a fundamental right, and Supreme Court was saying so in 2 judgments. But in 2 other judgments, the Supreme Court, in one it said that it is a limited fundamental right, and in another judgment it said that every citizen has a right to privacy. It did not use the word fundamental, but said that every citizen has a right to privacy. So there have been these at least 4 judgments where the Supreme Court has pronounced it. My basic point is Supreme Court has no power to create a new fundamental right.
That was the argument of the government.
I do not know. What I am telling you as a student of the Constitution, Supreme Court has no right to create a new fundamental right. But Supreme Court has all the authority to interpret the provisions in regard to fundamental rights. For example, it interpreted the right to live to include the right to live with dignity. So it can interpret the fundamental rights in the Constitution. It can read certain rights in the given fundamental rights. I hope in this judgment also they have said that right to privacy is included in Article 21 or whatever. That they can do, but they cannot say that it is a fundamental right in the Constitution, because it is not there in the Constitution. Only the Parliament by constitutional amendment can create a new right. What the Supreme Court can do, as it did in another case, freedom of the press. We cannot technically, strictly speaking, we cannot say that freedom of the press is a fundamental right. It is not. In fact, in the Constitutional Commission, we suggested in 2002 that it should be included as a fundamental right. It is not a fundamental right, but the Supreme Court has said that right to freedom of expression includes the freedom of the press.
In the Constituent Assembly debate, Dr. Ambedkar had said that it will cover media's right to report and all. But in this case, the Supreme Court has done exactly what you are suggesting. They have said right to privacy is included in right to life and liberty and other fundamental rights in Part 3 of the Constitution.
Yes,
this is what they have.
But what the media is saying that they have declared it a fundamental right, that is wrong. My presumption is that they have only read it into
Article 21.
Existing in Article 21, 22, 14, 19.
One of the issues that is linked with this case, in fact, the Aadhaar scheme, it was from this case that the matter went to first 5-judge bench and then to a 9-judge bench. What kind of impact it's likely to have on the Aadhaar scheme? Because that will be separately examined by a smaller bench based on this verdict.
Nothing at present, because the Aadhaar case is before the court separately, and when the arguments take place, then all that will happen, that this judgment, according to which right to privacy has been given greater credibility, that will have some impact on the discussion. But as it is, it does not directly affect the legislation in regard to Aadhaar card. Because no fundamental right, even if you assume it as a fundamental right, no fundamental right is without limitations and without restrictions.
Including right to life.
Every right has certain limitations and restrictions. there is no absolute right and there is no absolute fundamental right. So certain restrictions. Now, the question that will have to be decided whether the restrictions on right to privacy that the legislation regard to Aadhaar, what restrictions it places on the right to privacy, whether those restrictions are reasonable or not reasonable, whether they are permissible under the Constitution or not permissible.
In fact, regarding Aadhaar, when the petition was originally filed, there was no law on Aadhaar. It was done through an executive action, and that is why Justice Puttaswamy had challenged
Now
it.
there is a law.
Now there is a law. So the basic challenge to Aadhaar scheme is gone because there is a law to back it. One of the important things that the judges have discussed in the judgment is about Section 377 of the Indian Penal Code, which criminalizes homosexuality. They have not declared it unconstitutional or anything, but they have discussed it. And one of the implications it's going to have is on this case, because this issue is pending before a curative bench in the Supreme Court. After this verdict, what kind of impact it's likely to have on Section 377? Because right to privacy is one of the main grounds which the petitioners have taken before the Supreme Court.
Right to privacy has many facets. It's a very multifaceted thing. There are all kinds of right to privacy even without this judgment. For example, every woman has a right to privacy in regard to her body. You cannot compel her to expose her body. But we know that she has a right to expose. It's the question of her own choice. In films we see certain actresses agree to expose more, certain actresses agree to expose less. So, two kinds of limitations are there. One, the person concerned can himself or herself put limits on her right to privacy or his right to privacy. Or he can surrender the right. He can sell the right. Certain private rights are sold. He can sell the right or he can limit it. Can surrender, limit or sell. Second, the state can put certain restrictions. Supposing you go to a bank and want a loan, the bank may insist on a thumb impression. You have a right not to give your thumb impression or other biometric details. But if it is a condition for your getting the loan, you may surrender that right of privacy of not giving the thumb impression. Even now, the illiterate people give their thumb impression wherever it is necessary. Can you say that the right to privacy is being violated when the thumb impression is given?
In fact, one of the issues relating to this was when the Finance Act linked Aadhaar with filing of income tax return. That was decided by a separate bench which upheld the government decision, and then everybody is linking Aadhaar with
the state extends certain facilities or gives certain rights to citizens, and while giving those rights or those facilities, a state may lay down certain conditions, because nothing is without reservation, nothing is without restrictions. Every fundamental right in the Constitution is also subject to reasonable restrictions. So in each case it will have to be decided whether the restrictions that are being placed are reasonable or not reasonable.
One of the important points of this judgment is, though slightly unrelated, that Justice D.Y. Chandrachud has written a judgment and it has been signed by 3 other judges. And that judgment has overruled the judgment in ADM Jabalpur, in which his own father was on that bench, Justice Chandrachud Senior. And that judgment has been specifically overruled by this judgment.
4 of the 9 judges will not make a majority judgment.
No, not make a majority, because we are still to read the entire judgment. There are 6 judgments, but there is one judgment
which has been signed by 3
others.
So it makes it only 4.
Only 4.
So it is not a majority judgment.
We are yet to read.
So cannot overrule.
We are yet to read other judgments, not in technical sense, but he has written that judgment stands overruled. I am asking, after 41 years, because ADM Jabalpur came in, if I remember it correctly, 1976, during emergency. After 41 years, what is the importance of Supreme Court specifically saying that this judgment stands overruled?
Well, so far as the judgment is concerned, it was considered an aberration, always. So in many matters and in many respects, it already stood overruled, even though not specifically overruled by a subsequent judgment.
But this judgment, after 41 years, any academic value or anything?
As I said, in effect, that judgment was disowned by the whole country and by the judiciary itself and by the legal fraternity.
And whatever the problems were, they were rectified by 44th Amendment.
That's right.
Because that amended the Article 352 and 358 and 59. Yes. One of the issues relate to data protection. And now we are in the age of social media.
I think all that will have to be decided when the Aadhaar case comes up. What restrictions it places on the right to privacy and whether they are reasonable. Whether the state has the right to put those restrictions. Are those restrictions reasonable? Are those restrictions permissible? That will have to be decided by the court in the Aadhaar case itself. Because its present judgment does not decide the question of the legitimacy or virus of Aadhaar.
Present judgment, basically it lays down the basic law on right to privacy, and then individual cases. One of the cases regarding data protection, it relates to WhatsApp privacy policy. And that has been referred to a constitution bench. In fact, a 5-judge bench headed by Justice Deepak Misra had been dealing with that. And they stopped hearing. They said, we'll wait for this 9-judge bench verdict and then accordingly we'll proceed.
The technology has progressed so much that certain rights which you considered very legitimate under right to privacy, it is impossible to implement them. Now the drones and satellites enter your house and take pictures. Earlier, it would have been considered breach of privacy. But today, it is not. The whole social media, not only WhatsApp, but the entire social media, the Facebook,
Instagram,
Twitter, all these, they enter your even bedroom.
But one of the issues in the WhatsApp privacy matter is that WhatsApp is part of the Facebook group now. And whatever data we are sharing on WhatsApp, they are saying they can use it for their companies and for their business corporate thing. Whether that can be permissible or not, that's the issue.
That will also have to be decided. It has not yet been decided. That will also have to be decided by the court. And the court, I think, has admitted or pronounced that limitations, they have not questioned that restrictions can be placed, but all that they are saying is that those restrictions or limitations can be defined. So the court will have to define.
And it will be decided on a case-to-case basis.
Yes, and it is very important, it will have to be decided on a case-to-case basis. Even by defining, you cannot make it of general applicability. In each case, they will have to define it.
The issue of pornography. Again, there is a petition pending before the Supreme Court. There is another petition challenging the validity of two-finger test conducted on rape victims. All such issues. There are people who are saying that after this verdict, there is possibility that these cases may be decided in a particular manner.
I don't think, as I submitted to you, each case will have to be decided separately. And in that case, what restrictions on right to privacy are being placed, whether they are reasonable, whether they are necessary, will have to be decided. We cannot generalize and say that after this judgment,
this is going to be like this.
I don't think we can do that.
Dr. Subhash Kashyap, thank you very much, and let's hope that this verdict will go a long way in ensuring a right to privacy of citizens, and also it will ensure that the state also has right to regulate such things and provide basic facilities. Like in Aadhaar, it is about direct benefit transfer to citizens. So all those things are regulated in a proper manner. Thank you very much.
Thank you.
You were listening to a discussion on Supreme Court's decision on right to privacy. The participants were Dr. Subhash Kashyap, constitution expert, and Satya Prakash, journalist. This program was produced and presented by the News Services Division of All India Radio. This program is also available on our website, newsonair.nic.in. You may email your opinion about this program at airnsdtalks@gmail.com.